What up? What up? What up? Give me a link with Charlie if you can hear me loud and clear, man. Hopefully y'all are having a good day, having a good time. It is about that time, man. It is about that time. Time to find a freaking lighter that works. Hey, man, Benchmade has responded. Benchmade has responded. Let's go over these court documents, but let's just talk about what's been going on. Hopefully everybody's having a good day. Let me know where you're at, what the temperature is. It is 76 degrees in the man cave, 84 degrees in my little area of Plano, Texas. Humidity makes it feel like 90 degrees. So I'm going to try to keep my AC turned off for the sake of keeping the noise down, but I'm not letting the man cave get above 78. So it may kick on by itself. Okay, just giving you guys a warning. But hopefully y'all having a good time and all of that good stuff. I already got folks kicking in the door. Folks already excited to be up in this mix. I appreciate y'all. It's an interesting thing. People kind of been hitting me up like, X, why are you still talking about this? Well, I mean, people find this interesting. I find it interesting. I used to write contracts for a living. Now I audit contracts for a living. I used to teach at Texas A&M School of Law. I'm into knives, not heavily into them, but, you know, enough to where it piques my interest. So, you know, I want to talk about this stuff. We got 80 degrees in Michigan, says Ryan. 82 degrees in New England, says Thor. It's beautiful in Las Vegas. Folks got some good temperatures, man. You know what I'm saying? Folks got some good temperatures. Mike and Ike's EDC, thanks for stopping by. Thanks for being a goddamn member. We appreciate that, man. Hey, he says, good afternoon to everybody. He's working, but he's listening as well, says Blessed Nice. Thank you for kicking the door in and all of that good stuff. Birdman is here. What up, man? Thank you for kicking the door in. Thor, thanks for stopping by. Thanks for being a goddamn member. We appreciate that, man. Hopefully you're having a good one as well. J.M. Martin says, bet Benchmade came down on the side of stupid. Lefties always do. Hey, man. Hey, man. Spit your bars, bro. Spit your bars, man. All right. While you spit your bars, let me get this damn stick lit. I guess we can talk about what I'm going to be smoking on while I'm kind of going through this stuff. I think this is a Bistoff Christoph, if I'm not mistaken. This has a really unique band. It's kind of hard to see in this light, but it's like a skull and nice little shorty to smoke during my lunch hour with you guys. Chose my lunch hour just because I knew I would have some time to actually go through these docs and enjoy a stick and maybe have an energy drink and stuff like that. What did you vote on the poll? I'm a black coffee type of guy, and I'm also an energy drink type of guy. That's what we're about to do right now. And a ghost Swedish fish. So we're about to have that at the moment. Oh man, this stick has everything I needed to do. In the pocket today is a Kubi Vagrant M390 blade steel. This is a nice little carry, man. I'm trying to just figure out some more budget carries that have like a little bit of better blade steel on them. That's what kind of drew my attention about this one specifically. So I'm gonna just kind of give it. I had this in autumn. I gave that away, and I'm not a big fan of autumn. If you guys know, or if you don't know, I'm not a big fan of autumn. So but I'm still rocking this thing out of M390 blade steel. It's really, really tough. Like the detent needs work. Like I'm opening it like it's a damn, almost like it's a lockback, but it's a liner lock. It's so weird. I can't flick it barely with my, like I can flick it with my index, but it's tough. So I'm gonna have to work this out more. I don't carry it enough to work it out as much as I could, but you know, it is what it is. Also in the pocket, we have the Olight. I think this is the i3 EOS or whatever they call this shit. And come on, camera, participate. But this one here is a smaller. This is right now. Olight's giving this away as a gift. If you just register, yes, the i3 EOS, and they're kind of giving this away as a gift if you just sign up for their website. So I don't know. I'm not telling you to do that, but I wanted to just test it out. I'm wearing freaking joggers type of shorts, and I wanted something lighter weight in the pocket. And then we're in the middle of switching over. Okay, I'm done with my testing for the Data Crew snack time sling, the new version that they had. I'm done testing out the new version. Okay, so everything that was in here is being moved over to the Waterfeld sling that has Grandpa really excited. This thing has me thinking that this is what the nutsack speed sling should have been. And I don't want to cream all over this thing too quickly. I gotta really put it through its paces, but I'll just say that I'm thoroughly impressed with literally 2 days of usage. Thoroughly impressed with literally 2 days of usage. So, of course, we got to see how that goes, man. And then we're rocking we'll take the watch off. I have this little watch winder that I keep on my desk. And I'd like to keep my Ben Roos watches here. So this is the Ben Roos Field Watch. And then next to that is the Ben Roos DT. What is this thing called? The Ben Roos Dive Watch, the Type 1. There we go. Let's see. There we go. So that was in here. And so that will spin and just keep my field watch going. And then next to that is the dive watch, which I've been wearing. So I'm a big fan of my little Ben Roos collection as well. So just something to keep things interesting. Kind of stuff to keep things interesting, man. Let me know what y'all are carrying in your pocket. We're going to jump into everything that's going on here. Just giving a little bit of time for people to jump up in this mix real quick. So we have the Benchmade situation. The Benchmade situation is very interesting. I'll give you a summary of what's been going on, but let me say what up to a couple of other folks as well. Hey, Thor, I said, appreciate you. Like I said earlier, bro, who cares about the Benchmade and MKC, says Pierre. Hey, man, you can exit stage left if you don't want to watch it. You know what I'm saying? Everything's not for everybody. You know what I'm saying? So hopefully I'll make some other content that you like. This might not be for you. And let's see. Ryan says, hit that like button. Appreciate the reminder on that. Absolutely, man. Smack that goddamn like button, man. Let folks know that you're having a good ass time. I appreciate that. Tater Don moderating, coming in, making that shit happen. Appreciate that. We appreciate that overall. Benjamin Reed, thanks for stopping by. Thanks for being a goddamn member. We appreciate that, man. Super well appreciated. Let's see. 80 degrees in Michigan. Thor has 82 degrees. Vegas, Dad, thanks for stopping by. Thanks for being a goddamn member. We appreciate that, man. Hey, all, gonna watch and listen until I fall asleep. You must be overseas. Or you just sleeping during the middle of the day. One or the other, right? One or the other. Oh, we're going to have to get a secondary lighter. Because if this thing's going to be going out a lot, we're going to have to make sure we keep this thing up and running. I'm about to jump into this in a second. Just wanted to give a few folks time to get up in here. YouTube notifications are slow sometimes. Black coffee, tea sometimes. I quit drinking soda energy drinks like 20 years ago. So, yeah, only energy drink I will mess with is Ghost energy drink. Mainly because it's a clean energy. They don't use sugar. They extract the caffeine from coffee beans. You know what I'm saying? So it makes stuff interesting. It does make stuff interesting as well. Real Chris Brown, appreciate y'all kicking by. Oh man, maybe I need to put some respect on your name, because obviously folks are blessing you in the chat. I need to look and see who you are, man. I appreciate you kicking the door in, and for me failing to put some respect on your shit. Let me go to your channel real quick, man. Let me visit your channel and all of that. So anyways, man, so let's talk about this Benchmade situation. So Benchmade sued Montana Knife Company, but let's rewind a little bit and just kind of get it says Manila, 12:13 a.m. in Manila. Got you. Benchmade Knife Company sues Montana Knife Company in Oregon District Court. It's a federal court. They're across state lines. I guess that's what the best course of action, all that good stuff. Let me summarize what happened and summarize where we are now. So they filed a federal lawsuit against Montana Knife Company mid-March, March 15, 2024. And so they subsequently terminated their own lawsuit April 8, 2024. Voluntary dismissal by Benchmade in federal court as well. So details surrounding the lawsuit are still emerging. Let's just keep that up front. I've been getting the court documents. I've been paying 10 cents per page and downloading the court documents and reading them myself. Anyone can do this. So when I show this stuff on the screen, YouTube, I'm not doxing anyone. I'm not doing anything special. Anybody that's in chat or anybody that has a credit card and knows how to click clack on the keyboard can do the same thing that I'm doing. All right. So let's just talk about the specific nature of the accusations. Benchmade is suing Montana Knife Company, alleging that MKC interfered with the former Benchmade employees' confidentiality agreement. That's number one. And number two, they also say that Montana Knife Company conspired with this former employee to allegedly possibly get trade secrets. We're going to dive more into that here in a second. So Benchmade claims that former employee had a confidentiality agreement, or more likely, better said, a non-compete, in the form of a non-compete that restricted him from not only sharing information about Benchmade, but working for a competitor for a set amount of time. In this specific situation is 2 years. Also, they accused Montana Knife Company of conspiring with the employee to breach breach the agreement and to possibly bring over trade secrets. Now, I think that this is a interesting thing that's going on because it's a lot that they've been, that they kind of talked about here. So Montana Knife Company has denied the accusations that they didn't poach the employee. They've also denied the accusations that they conspired to get trade secrets. They've denied both. There's also questions about Benchmade's attempt to resolve the issue before they sued, meaning before they filed the lawsuit, there's questions about what did Benchmade do to resolve this issue before they just filed a federal lawsuit. That's still something that has to be litigated and talked about. Both sides have filed different documentation in court. Overall, this is an ongoing legal battle between the two knife companies. I'm going to keep following it, and this is the most recent update as of today. May 3rd, 2024, Montana Knife Company filed for sanctions, Rule 11 sanctions against Benchmade. They wanted Benchmade to pay their legal fees and their court fees. They had to pay a fee to file the motion, and then they also had to pay a lawyer who is Tim Palatori. He's former President Trump's lawyer. He used to be his lawyer to former President Trump. But he's still seemingly still in good graces with Trump. And, I think he's a great lawyer. I think he does a good job. He's represented people like Eddie Gallinger, the Navy SEAL who was accused of all those war crimes. He's represented former police commissioner of New York. He has represented a former governor of a state, former mayors. So some big names. And so, I think he's the probably, if anybody was for the job for Montana, I think it was for him. Now for Nika Aldridge, I've never heard of this attorney for Benchmade. I think he is he works for Schwab, Williamson and Wyatt law firm. I've never heard of him, but Benchmade has him knocking it out as well. So they got two different opposing sides. So up until this point, I have since interviewed Montana Knife Company's owner and interviewed Tim Palatori and get their opinions about what's going on. Now we jump into where we are today, and I'm going to read this complaint. I'm going to read this response. Then I'm going to give you the official response that I got from Montana Knife Company and from their lawyer last night. Then I'm going to give you my opinion about what's going on, and let's just see if we can get through this pretty good. Now, just remember, guys, I am not a lawyer. I'm not a lawyer. I don't play one on TV. I downloaded these documents just like any of you could do as well. And I'm reading these with with my own abilities for the best that I can. I'm not doxing anyone. As I mentioned earlier, all this stuff is publicly available. So this is their response. This was filed on May 17th. Now, the reason I waited to do this live stream is because I've been watching the content on YouTube, and a lot of folks are getting a lot of facts wrong. And I think that people really need to, whether in your EDC community or the knife community, really digest this information before you just go out and report it. People are just misreporting this left and right. And Benchmade is a litigious company. I just don't want folks getting themselves caught up because they're getting the facts all jacked up. Okay. So plaintiff's Benchmade response in opposition to Montana Knife Company's motion for sanctions. So as remembered, Montana Knife Company wants Benchmade to pay for their legal fees, and they want them to pay for the court fees for having to file that stuff. And I'm just going to keep this real. Like, Montana Knife Company was not happy that Benchmade self-dismissed this case 2 days before they were about to submit their response. So they dismissed it on April 8th. I think they had to make the response April 10th. So up to that point, MKC they're paying legal fees. They're putting in man hours. They're putting in work. And it was self-dismissed with no explanation. That was one calculation on to the decision for MKC to file for their own sanction to get their legal fees paid. Not only that, but they also kind of felt slighted because, according to my understanding, is that you dismissed this case on the 8th. But you accused us of being a co-conspirator. What made you dismiss it? Right? You should pay us our legal fees. That's how the kind of summary what I got from them. So this is Benchmade's response. MKC's unsigned motion for sanctions, supported by 2 unsigned declarations, relies on false assertions of fact, misapplies the applicable law, and other meritless. Shots fired off the first sentence. Okay, Benchmade, calm down. They're not playing around. They're not playing around. They came out the gate with their own summation. Okay. Contrary to MKC's unsupported assertions, Benchmade complaint was well pleaded based on thorough investigation and proper application of the law. Ultimately, the former employee at the heart of the case agreed to abide by the terms of the contractual obligations to Benchmade, and basically it litigated the need for protracted litigation. In other words, Benchmade said that the employee decided to follow the non-compete and we don't need to sue anymore. That's what that sentence seems to read to me. Benchmade then voluntarily dismissed the case before a responsive pleading was due. Notwithstanding, MKC seeks sanctions based on a statute that concerns lawyers who vexatiously and unreasonably multiply the proceedings, meaning extend the proceedings. The swift resolution of this case is the opposite of MKC's motion. Arguably, otherwise is without merit. MKC's motion should be denied. Hit that like button, bro. If I might have to pull out these goddamn dictionary of words, hit that goddamn like button. I won't ask you for anything else, but smash that like button. So they want to deny. They think that, hey, listen, he said that he was going to now follow his non-compete. So we decided to voluntarily dismiss it. MKC, we don't know what you're complaining about. We think we resolved it steadfastly. What else is there to talk about? Now, here's the point where they blot out the employee's name. Listen, I keep it real with you. I did a quick Google search. You can see who the employee is. This is all blotted out. And there's also some motions that were filed by Benchmade that were filed under seal. And I guess they'll be unsealed in the future. And, I guess they're blotting this out to provide his confidentiality, but they didn't blot out his position. They didn't blot out, I found him in 30 seconds. I'm not going to say his name. I'm going to say John Doe, and I'm just going to keep going from there. So here's a statement of fact. It is John Doe's 2-year non-compete agreement with Benchmade. Benchmade is an industry leader in manufacturing. Now they're about to start stroking their ego. This is what they did in the last time I did this type of video, and I kind of breeze over some of this stuff because it can they're speaking a lot of patting themselves on the back, which you should do in a motion, right? But also a lot of it is it's opinion. So Benchmade is an industry leader in design, manufacturing, and sale of knives. Some of that could be fact, some could be opinion, right? If they're leading in the sale of knives, that's a objective fact. If they're an industry leader, that could be subjective. So I'm just going to take it. You take it as you see fit. So Benchmade has been manufacturing and selling superior quality knives in the U.S. for 30 years. Jump into paragraph 2. Until recently, John Doe was a Benchmade's director of manufacturing innovation. That was his or hers title. Well, I'm going to say his because it is a male. And it says Mr. at the footnote at the bottom. So concurrent with his commencing employment at Benchmade in 2015, John Doe executed as a condition of his employment a non-compete with the following non-competition clause. During the term of the employee's for a period of 2 years after termination of the agreement, he shall not work for any other business within the territory directly or indirectly. They define territory as, in my opinion, and in the opinion of Montana Knife Company, the world. It's just kind of how it read to me, but maybe I'm wrong. Okay. Territory is broadly defined as nationwide is what they put here. Then they further went to define it more in the actual agreement, but that's kind of neither here nor there. Right. So under the heading proprietary rights to information and materials, the agreement also prohibited John Doe from disclosing or reproducing or duplicating any Benchmade Knife Company confidential information. All right. So up until this point, have we heard anything about Montana Knife Company? Up until this point, have we heard anything about Montana Knife Company? We're under statement of facts. We're under section A of statement of facts, but we're talking about John Doe and what he agreed to. Okay. So he agreed to not work for another company for 2 years. He agreed to not work for another company generally nationwide. He also agreed not to reproduce or duplicate any of Benchmade's Knife Company confidentiality materials. That can be with a cell phone or whatever. Okay. John Doe indicated his intention to take actions contradictory or contrary to his non-compete. In late February, I'm assuming 2024, John Doe gave notice that his direct supervisor that he would be terminating his employment with Benchmade. In a subsequent discussions, he also disclosed that he reached an agreement with defendant MKC to take employment with MKC 1 year after termination of Benchmade, notwithstanding his 2-year non-compete. Here's the thing that has me confused, bro. This is what has me confused. I used to work for a top 4 consulting firm. When I left that firm, I just put in a 2-week notice and left. I didn't tell them where I was going. I quit properly. I'm confused. Like, why are you letting your supervisor know not only that you're leaving? I guess you need to do that, but why are you telling him where you're going to work? That's the part that I don't get. Does the non-compete say you have to disclose where you're going? What if he was quitting to go work at McDonald's? Like, does it say you had to do that? What's y'all's experience with that? When you quit somewhere, do you tell them this is where I'm going and this is the type of car they're giving me and the type of phone they're going to give me and my parking space? I don't know. That feels a little weird to me. But anyways, he says he's going to go work for MKC 1 year after his termination date, notwithstanding his 2-year non-compete. Okay. He explained that he intended to work for a different company outside the knife industry during that 1 year period of time. He told Benchmade that he was advised that non-competition agreements in Oregon were valid for 1 year. So he was told that he only had to go 1 year, even though he signed a 2-year agreement. There's a footnote that says MKC alleges without support that the employee spoke with plaintiff's general counsel, who informed him that non-competes are enforceable for 1 year in Oregon, including his own non-compete. Had the case been alleged, the accuracy of an allegation would be contested, meaning that they think that MKC either is alleging information that's not true or they were told information that's not true, one or the other. Indeed, pursuant to Oregon's, and then they cite Oregon law, the term of a non-compete may not exceed 12 months from the date of an employee's termination. However, the John Doe signed his agreement. The statute allowed non-competitions up to 2 years. So this is kind of like a part where I guess Benchmade was ready to fight to keep him under wraps for 2 years. So that's what the rest of this paragraph says. And they think that the 12-month restriction would not apply. That's basically their summary. That's something that they're going to have to litigate. I don't know if that's true or not. Okay. John Doe agreement to take employment with Montana Knife Company, a competitor in the knife industry, in only 1 year was a facial violation of the contractual obligations at Benchmade. So up until this point, have you heard anything that MKC has done? I don't know. Have you heard anything MKC has done? So the first part they talked about, he signed a non-compete and agreed to not do certain things. The second part, they're kind of talking about when he left and what his intentions were to do. Here's part C of the statement of facts. Swab. So I guess Benchmade reasonably investigated. So they're talking about the law firm. And so they said the law firm and Benchmade reasonably investigated before filing the suit and discovered further breaches by John Doe. Here's the part where MKC didn't know what the hell Benchmade did before they filed the suit. Now, Benchmade's about to explain what they did before they filed the suit. In early March 2024, Benchmade sought legal advice from Schwab about John Doe's intentions to work for a competitor in just 1 year. So here it is. He told him in February he's leaving. They immediately go talk to a lawyer. I don't know. I listen, the non-compete is in this paperwork. I'm not going to read the whole thing. You guys can read it if you want to. It's very long, wordy, and I don't understand parts of it. Maybe the non-compete required him to disclose that he was going to go work for somebody else. I don't know. That's the part that has me confused. Okay. So the law firm did an investigation, and they basically wanted to know everything that had to do with John Doe's notice that he was about to resign. The undersigned counsel had a Teams video call with Benchmade's general counsel and its executive vice president. Golly, this went high up the food chain. Counsel had follow-up calls on March 8th, 11th, 12th, 13th, and 15th. The run up to the week of them filing the lawsuit, they were on the phone with lawyers outside of Benchmade talking to the lawyer inside of Benchmade and to the executive vice president of Benchmade. As part of the investigation, the undersigned counsel interviewed a number of additional Benchmade employees, including John Doe's direct supervisor and Benchmade CEO. So, okay. So they interviewed a buttload of folks, right? John Doe's direct supervisor provided a comprehensive narrative of the conversations with John Doe and explained his plans to with respect to MKC. So here it is right here. So let me give you, like, for me personally, I left my current job back in 2017. I left for 2 years. I went for a promotion, and then I came back in 2019 after I worked at that. I didn't really like the position I took. But my point being is, when I left in 2017, you know, I didn't tell my supervisor back then, who is my supervisor now. I have the same supervisor. Didn't tell her where I was going, who I was going to work for, any of that stuff. And, you know, but I'm not under the same type of non-compete. I don't know. So meanwhile, John Doe was leaving Benchmade to work for a competitor. Benchmade's IT team conducted an internal investigation to John Doe's email files. This is where it got interesting as I was reading through this and getting sleepy on my nightstand last night. This woke me up, guys. This woke me up. In the process, they discovered that in the months leading into his apparent employment agreement with Montana Knife Company, on numerous occasions, he emailed highly confidential documents containing Benchmade trade secrets and other confidential information to his personal email address. What? He did what? This is what you're alleging, huh? Okay. So let me pump the brakes. Have y'all still heard anything that MKC has done? Anybody? Has anybody heard anything that MKC has done? I just want to read this as I'm taking it. Okay, maybe we're getting there. All right. So they're alleging that they dug into his IT records and that he allegedly emailed a bunch of documents to his own personal email. Those documents included confidential information about employees, anticipated capital improvement plans like equipment for their warehouses and stuff like that, expansion plans including maps, so if they're going to be going into different places around the world, maybe different parts around the country where they're not already going, maybe hiring or having other facilities, architectural drawings of Benchmade facilities, revenue goals, operational goals, expanded margins, flow charts following the manufacturing process. This is a lot of stuff. Benchmade's future outlook and forwarding a 24-month planning for Benchmade infrastructure planning capital expenditures. If this is true, this is a lot of stuff he emailed himself. If this is true, this is a lot of stuff that he emailed himself. Am I tripping? I don't know, man. So many of the proprietary documents were stamped confidential. And then they cite a case where, I guess, stamping something confidential is something that you're allowed to do. I don't know. I'm assuming that's what that means. Benchmade IT engineers also did a more comprehensive search of John Doe's email files and found that as far back as its email files were retained. So as far back as email files were retained, we don't know that date, but he started working in 2015. I don't know how long they maintain email files. For me, my email files have been here since I started working here, so mine have been here for a decade, but I don't know. Even when I left for a while, they still had my emails. John Doe had never before sent confidential Benchmade information to his personal account. So they said that we went all the way back. And when we went all the way back, you weren't doing this. Nor was there a legitimate reason for him to do so. John Doe had the ability to access company systems from home via a VPN. Okay. Same thing here. I access my work email through a VPN, and I have a whole separate system for it. Monitor, computer. I don't even intertangle anything. I just use my work computer separately. The undersigned counsel spoke directly to two IT engineers who performed this investigation work and supplied copies of the emails and underlying attachments. All right. So up until this point, have you heard anything that MKC has done? Anything? No. Here's a question I have. If y'all found all this out before March 15th, okay, why did y'all only sue Montana Knife Company? Why didn't you sue the employee? I am actually, that's a legit question. I don't know the answer to it. Maybe it's rhetorical, but if y'all did this investigation before March 15th, why did you sue MKC? Why did you not sue the employee? Is it because you know his salary? You know you can't get anything, but if he has documents, wouldn't you sue him to make him provide to cease and desist your having your documents, to delete them? Like, wouldn't that be? I don't know. That's just my opinion. All right, let's go to part D of the statements of facts. We're about halfway through this doc. Benchmade filed suit against MKC and dismissed it immediately after the relevant harm had been, I guess, I don't know this word. Let's just say alleviated, ameliorated. So this is what they're saying happened next. They did all this investigation and they dismissed the case after it had been alleviated, is what I'm going to go with. But up until this point, I don't know what MKC has done. I guess they're about to explain it to me, right? On March 15, 2024, Benchmade filed the instant lawsuit solely against MKC, alleging intentional interference with a contract. Specifically, Benchmade alleged as follows. Benchmade had a contractual agreement with the unnamed co-conspirator, John Doe, in the form of a non-compete. So they believe that John Doe owed Benchmade a fiduciary duty or loyalty. Upon information and belief, MKC was aware of the non-compete clause in a confidential agreement and specifically aware of the 2-year compete, and further knew that this clause prohibited them from working. Now, what they're saying is MKC was made aware by John Doe that he had a non-compete, and the clause prohibited him from working for MKC. That's what they're alleging. MKC intentionally interfered with Benchmade's contractual requirements. This is the part that has me a little confused, because if they were informed that he could not work for them and they offered him the job, let's just say that they did offer him the job, right? And he accepted the job. I'm still confused. I'm confused why you go after MKC versus the employee and seek an injunction that way, but maybe I just don't know what the hell I'm not a lawyer. Maybe I don't know. Maybe I don't know. Upon information and belief, MKC interfered with the improper purpose of obtaining Benchmade's confidential information. Now, I don't know how they jumped to this conclusion because of the employee's actions. Everything that we read up until this point is what they are alleging that the employee did. And they also put MKC as a co-conspirator. And this is where I think is interesting. I'm interested to see MKC's response to this because I don't know how they get to this conclusion. I don't know. MKC also interfered with improper means. Specifically, it conspired with John Doe to breach its fiduciary duty. That if they litigate that may or may not be true. I don't know. But the first part, to get the confidential information, that seems like a tougher thing. But I guess we'll find out more, right? Benchmade was concerned about the permanent reputational damage that could befall John Doe from these allegations. Accordingly, in avoiding naming him as a defendant and also avoiding using his name or title in the complaint instead of referring to him as unnamed co-conspirator. So that's why they're saying they decided not to name him in the initial complaint as a defendant. They decided not to sue him. And they also decided to not even use his title because someone like me can just Google it. And they were concerned about his reputation, I guess, being able to work in this industry in the future or get another job in the future. If somebody just Googles his name, even outside the industry, maybe they can find out that he was involved in litigation, and they may not like that. But it seems like they took the gloves off on John Doe, right? However, Benchmade executives separately confronted John Doe with its findings concerning the email investigation in the meeting that took place on March 20th. So they decided to sue MKC, and I guess they decided to confront John Doe after they filed the complaint. At the meeting, Benchmade presented John Doe with a draft amended complaint that further named him as a defendant, detailing the emails he had forwarded to himself and added claims against him personally for misappropriation of trade secrets under the Trade Secrets Act violation, breach of fiduciary duties, etc., etc. So at that meeting, they said, hey, we know that you emailed yourself this shit. Here's a draft complaint that we're about to file. We're about to file this complaint. And I'm assuming they say unless you do this, because they didn't file the complaint on March 20th. So when you present a draft to a human and then that draft doesn't get filed and becomes real, you must have told them we won't do that unless this happens. Or am I jumping to a conclusion? So Benchmade's executives concluded that John Doe, Benchmade's executives concluded by making John Doe an offer. Oh, they did make an offer. Key terms included in John Doe's returning all confidential information. That's number one. Providing complete disclosure to Benchmade so the Benchmade could remedy any misappropriation. I don't know if this is like letting them get access to his electronics. And agreeing to abide by the 2-year non-compete. So this is the 3-part thing that they asked him to do. You do these 3 things, I guess this draft won't become real. Additionally, given the nature of the highly confidential documents that he forwarded to himself while apparently in negotiations with Montana Knife Company, Benchmade included a 4th, that Mr. John Doe would not work for MKC for 4 years. So you said, bro, you said you wanted your stuff back. You want a complete disclosure for to Benchmade so Benchmade could remedy any misappropriation. Agreeing to abide by the 2-year non-compete to not work for any other knife company. And then as a 4th one, you stuck it to MKC by saying you can't work for MKC specifically for nearly half a decade. Let's sum it up. Nearly a high school term for, well, most of us, unless you're a dummy. A 4-year college degree. Halfway to becoming a doctor. 4 years. You can't work for MKC. So that's what they wanted. They wanted 4 things from John Doe, and they wouldn't name him in the complaint itself. In exchange for all 4 of these, terms, Benchmade would provide John Doe a complete release of all past conduct and would not file the amended complaint. Then they gave him 48 hours to respond. So he left the meeting. He did not have to respond. Let me tell you something, man. If that was me, I think I would have left that meeting as soon as, if I would have walked in there, I no longer work for them. I think I would have left that meeting as soon as I saw lawyers and executives. I would walk through the door, lawyers and executives. Oh, I'm leaving. I'm out of here. Email me whatever y'all got going on, man. Email, just send it to me or file it or something like that. It's just icky. It feels icky. All right. On March 22nd, 2024, the undersigned counsel was contacted by an attorney who had been retained by John Doe to represent him with respect to this matter. The attorney requested an extension of time to John Doe to resolve this settlement offer, which Benchmade granted. Okay, that was nice. The undersigned counsel and John Doe attorney then negotiated terms of a settlement agreement over a period of weeks. Ultimately, John Doe agreed to return all of Benchmade's property, allow a forensic analysis of his computer equipment, to provide an interview with Benchmade's counsel, and to abide by the 2-year non-compete. He did not agree to the 4-year restriction specifically to Montana Knife Company, and the final settlement agreement does not include that term. Benchmade provided John Doe with a release while reserving the right to take additional action against him, both him and Montana Knife Company, if as necessary. So he hired a lawyer, and it sounds like all the lawyer did was get rid of the 4-year part. I mean, like, I'm not trying to be funny, but you paid money to a lawyer, and it seems like the only thing the lawyer got rid of was the 4-year part. You still had to give up all the crap. You still had to let them to do a forensic analysis of your equipment, whether that's your computer, your emails, your phones. You had to sit down for an interview, and you still had to do the 2-year. Why did you hire a lawyer? I feel like you could have negotiated that shit yourself. Maybe I'm tripping. I think I could have negotiated that shit myself. You could have went to eforms.com and just fucking printed off an agreement. You know what I'm saying? I don't know. I digress. So the settlement agreement reached with John Doe effectively mooted the case because he had agreed not to work for Montana Knife Company for 2 years. And they believed that alleviated the immediate harm underlying the complaint. Accordingly, once the basic terms of the agreement with John Doe were reached, Benchmade voluntarily dismissed the case on April 8th. So when did they come to this agreement? Okay, so they said that they negotiated for a number of weeks. Okay, so maybe this all took until April 8th to resolve. Okay, that's why they dismissed the case. Now, the one thing I said is, in your case, that you said that 2 things were happening. You said, number one, Montana Knife Company was conspiring to get your trade secrets. And number two, they interfered with a non-compete. I guess because you got your stuff back, you didn't think they were conspiring anymore, but you were, I don't know. I don't know. As of that time, no response pleading has been filed as none was yet due. So they're saying at that time there had been a response pleading filed by MKC. It wasn't due yet. Other than the initial filing documents, the only other docket entries were notice of appearance by the defendant's attorney, which is Tim Palatori, and pro hoc vice motion, which was granted in late March. So I've already talked about that on my other video. So, but they didn't explain to MKC any of this. I will say that. I feel like you had an open line of communication between your lawyer and Tim Palatori. I don't know why this wasn't explained. At least you're not putting. I think that if you did explain this to Tim Palatori, it would have been in another paragraph. Am I tripping? Maybe I'm tripping. Okay. So the defendants draft and filed motion. So now they've moved on. Have y'all heard anything up to this point of what MKC has done? Or like factually, other than alleged? Have y'all heard anything yet? I'm just wondering. Okay. All right. So let's get to the defendants draft file motion. So now they're going to take some shots at MKC's, motion for lawyers' fees and all that other type of stuff. Right. So after the complaint was dismissed, Montana Knife Company's New York-based attorney threatened to file a motion seeking sanctions. Hold on, let's pause for a second. After the complaint was dismissed, Montana Knife Company's New York-based attorney threatened to file a motion seeking sanctions against Schwab. First off, I'm not defending Tim Palatori, but I did a simple Google search, and his law office is in Arlington, Virginia. He does interviews in New York, but I don't know. I did a quick, a search. He's in Arlington, Virginia. I think when you're an Oregon company in an Oregon court and why do you name a New York based attorney? Does that matter to the judge? Cause this document, you're speaking to the judge. Ultimately, if this makes it in front of a jury, you're speaking to the jury. What is that? I don't understand that part. All right. But anyways, after the complaint was dismissed, Montana Knife Company's New York-based attorney threatened to file a motion seeking sanctions against Schwab. Specifically on Saturday, April 20th, Mr. Palatori sent a draft motions for sanctions to the underlying counsel. Now, one thing that they left out is between April 20th in that draft, there was conversations in the month of March. He didn't put that in here that they didn't respond to. At least that's what I understood, that Benchmade didn't respond to Mr. Palatori until the draft was sent over. So stating that he intended to file it on Monday and asked to meet and confer in advance of filing. The draft motion cited no evidence in support of the allegations and cited only two cases. One of them was internally cited as an Alaska state court decision. Moreover, many of the factual allegations were plainly false. First, for an example, contrary to the unsupported allegation, the plaintiff filed the instant lawsuit without even cursory investigation. Now, when MKC put that in there, they were going off of what they knew, right? Because up until this point, you hadn't talked to them, you didn't send a cease and desist, and they didn't know what you had done before you filed the lawsuit. So it could be false that y'all did it. It could be false that they put that in their document, but they couldn't have known that it was false if you didn't tell them what the hell y'all did beforehand. Or am I tripping? So both Benchmade and Schwab engaged in extensive investigations before filing this lawsuit. That would be like, me telling Mrs. X, we're getting divorced. And I just serve I send the paperwork to court and then right before the divorce action takes place, I dismiss the complaint. And she's going to be like, well, first off, why did you file it? And I'm like, oh, I heard you were cheating on me. And up until that point, she'd be like, well, what facts do you have? What investigations did you do? Et cetera, et cetera. And be like, oh, I found out that you weren't. So I went ahead and dismissed it. So if I put in my complaint, right, or if you put in your counter complaint, he said he's going to divorce me for cheating on him, and that's patently false. I don't even know if he did an investigation beforehand. I think that would be fair for Mrs. X to put in her complaint. The draft motion also stated that the plaintiff made no effort to speak with the employee until several days after the complaint was filed. Now, MKC's going off of what the employee told them. Okay. That was also false, says Benchmade. It was John Doe's admissions in the conversations with Benchmade that formed the basis for the complaint. The draft motion also stated that a 1-year agreement is a maximum permitted under law. And so that's what they stated that, but Benchmade doesn't believe that this is true. They were ready to fight that. They also said that as to John Doe's 2015 contract, that was incorrect as a matter of law. They were ready to fight that. That's something that they were going to have to fight. The draft also states that the plaintiff threatened to personally name him as a defendant in the lawsuit if he did not immediately sign a settlement. In fact, as explained above, they gave him 48 hours and suggested he retain an attorney. I mean, this seems like a real lawyerly statement. Think about this. The draft also falsely states, so they're saying that MKC falsely stated that Benchmade threatened to personally name him as a defendant in the lawsuit if he did not immediately sign an agreement. Benchmade said, no, we didn't. We gave him 48 hours. Okay. Now, the word immediately is subjective. So to say it's false, I think that could be a stretch. They're both adverbs, and this is subjective. What is normal to the spider is chaos to the fly. So immediately is defined differently by different people. Benchmade then granted extensions to while John Doe and Benchmade resolved the dispute. The draft also falsely suggested that Benchmade request for a 4-year restrictive specific to taking employment to MKC was illegal. The Oregon statute limiting employment non-competition agreement does not apply to the requested term in exchange for release and liability claims. So I guess they're saying it's more of a civil claim, not a criminal claim. I don't know. In any case, Benchmade agreed to withdraw that term in light of our compromises to that John Doe. What compromises? He gave y'all everything. He gave y'all 90% and y'all took away the 40. He gave y'all everything. I'm still confused why he hired a lawyer. Like, he gave y'all everything except for the 4-year part. Like, he just gave y'all the bag. In terms of a legal analysis, while the draft motion cited as a basis for its demand for fees, the argument section said nothing about the statute. MKC referenced only section 1927. So basically, Benchmade is fighting against paying these legal fees. They're fighting it, saying that not only did you cite something, but they don't think that what you cited is substantial for that. Then they go about multiplying the agreement, draft notion, reference to. Here we go right here. So jump into this paragraph here. The draft motion referenced 2 letters that Mr. Palatori sent, each of which made false and wholly unsupported accusations. Here's the part I have an issue with Benchmade. The draft motion references 2 letters that Mr. Palatori sent, each of which made false and wholly unsupported accusations. You left this paragraph very moot, and I'm confused why you didn't respond to his letters until he sent you a draft motion, because you're saying that his letters were false and unsupported. But according to the phone call you had, according to what Mr. Palatori said, is that you didn't even respond to his letters. Why didn't y'all respond and say these letters are shit? These are shitty letters. You're not right. You got them all wrong. Something like that. Notwithstanding the short notice, the undersigned counsel agreed to meet and confer with Mr. Palatori on a Sunday afternoon, which they did. Mr. Palatori asked to meet and confer again on a Wednesday, the 24th. However, without notifying the undersigned counsel or seeking a consent, Mr. Palatori then now admitted that he had recorded the conversation. Using an AI note-taking software to take down nearly verbatim notes. I don't know if I know he said he had 2 people listening and someone was taking notes. I don't know. Maybe it's legal. I don't know. He said that, however, without notifying the counsel, Mr. Palatori admitted that he recorded it. I don't see that Benchmade saying that was illegal. I guess that they're just butthurt that he didn't inform them. I will be butthurt too, though. Somebody record me, even if it is illegal, even if it is legal, I would still be upset. I would still be upset about it. You was recording me, bro. I think I would still be upset, even if it was legal. He did without consent. During the telephone conversation, the undersigned counsel explained to Mr. Palatori that given the substantial deficiencies identified above, the draft motion was meritless. Counsel also explained that he did not expect such a baseless motion to be favorable looked upon the court, and respectfully suggested that MKC not file it. That's something that basically MKC kind of conveyed to me. The suggestion was unsuccessful. MKC filed their motion on May 3rd, 2024. And it's not meaningful different than the draft, but there were few notable changes. For example, they filed as a file version, falsely claiming that that plaintiff and their counsel pulled the employee into a room. Mr. Aldrich threatened. I mean, this is what MKC was told. They only can go what they were told. Discovery hasn't happened yet. Okay. But you're allowed to say it's false, but that's what they were told. To the contrary, Mr. Aldrich was not there and has never seen John Doe nor spoken to him. This accusation apparently was nothing more than conjecture. As filed, the as filed motion also quotes out of context the improperly recorded meet and confer conversation. This is when they're talking about the allegedly conversation drafting some other knowledge. Okay, so they're basically just taking snipes at the rest of the declaration that Mr. Palatori sent, and et cetera, et cetera. Okay. Then they state this legal standard, which is the legal standard for them to be allowed to have the non-compete and the territories and all the other stuff. I'm not going to read that. So here's their argument. MKC motions fails to establish extensive base for statutory elements. This is them taking snipes of basically why they shouldn't have to pay it. I'm not going to read that. They also believe that MKC cannot prove the elements of unreasonable or vexatiousness. This is why they're also saying that they shouldn't have to pay the legal fees. Then they also say that MKC also faults Benchmade for not filing a motion for preliminary injunction. Now, this is one part that I was curious about when I interviewed Montana Knife Company. What Montana Knife Company and their lawyer said is, why, when you filed your initial paperwork, did you not file a preliminary injunction, like immediately stopping because y'all are accusing your employee of having confidential information? Why didn't y'all file a preliminary injunction? So they're saying, as demonstrated, however, such motion practice was unnecessary given the case was mooted by the separate agreement. Okay, but you still didn't address what Montana Knife Company said. If you believed he had confidential information, why didn't you try to get this thing resolved immediately? That's what a preliminary injunction does. Like, hey, judge, we know this might take 4 months, but can you please resolve it within blah, blah, blah weeks? Because this is, MKC might get our information next week. We need you to resolve this now. That's what a preliminary injunction does. And you didn't file that. So then now they're arguing that his non-compete is valid. And I'm not going to go through this part because we've already kind of talked about this. And this is something that they're going to have to fight in court if they believe it's valid. OK, but they think that it's valid. Some Oregon laws say 1 year. His compete says 2 years. I'm not about to, it is a little interesting, but I think that's it's much. But for numerous reasons stated above, they think that the judge should deny the motion. Basically, we don't think we should have to pay them anything. OK, we don't think we should have to pay him anything. That's what they're saying. So I think that's pretty interesting. OK, make sure you hit that like button, man, because we got another declaration that dives deeper, and they're going to actually explain. They're going to explain what they did in that investigation. They're going to explain what they actually did in the investigation. How did they go through the emails? These IT gurus looking at different stuff. Gabe says the problem is that they came after MKC. So if something was worked out, it needed to be with MKC, not the employee. That's a fair statement. If you come after MKC and you don't even come after the employee, you resolve it with the employee, and then you dismiss MKC, I will be standing there like, hold on. I'm just using a hypothetical number. I just paid this lawyer 15 racks. I just paid this lawyer $15,000, and you dismissed the case and didn't tell me why. I want my money. I want my 15 G's, bro. Now you're telling me like, well, we resolved it with the employee. Now, listen, to be fair to Benchmade, maybe they don't have to disclose all that stuff. I don't know. I'm not a lawyer. Maybe they should have disclosed the stuff. I don't know. It just really depends. Hey, Chef, thanks for kicking the door in as well, man. Thanks for kicking the door in as well. Now, the next part I kind of wanted to look at is this is Benchmade's lawyer. So remember the last time I did this live stream, I talked about Tim Palatori did a declaration about what happened to him, the phone calls that he had, all that type of stuff. Well, we have another example of a lawyer doing a declaration of what happened. I am not going to read all 54 pages of this. I'm going to jump around because some of it is I don't need to do. Okay. And it's long. And my lunch is not forever. So Benchmade Knife Company declaration of the lawyer in support of the plaintiff. Benchmade's Knife Company response to the defendant's motion. This is the lawyer attesting to what happened, testing what he did or what he observed or whatever. Okay. All right. He's talking about that he's a shareholder of the law firm. He was contacted by Schwab to have a new client, I guess, to be a client of to have Benchmade as a client. They talked about an employee that we've already talked about that. Let's jump into, let's see, where's some new information? Talked about that. During my investigation, I spoke to here. Okay, here it is right here. Now the lawyer is saying that he conducted the investigation himself. During my investigation, I spoke to two of Benchmade's IT personnel who discussed an investigation they performed after John Doe gave notice. They informed me that they discovered that in the months leading up to John Doe's termination, he had on numerous occasions emailed highly confidential information. I was provided with copies of those emails and underlying attachments. This is the stuff that they're saying that he sent to himself. And we talked about this already. This is a lot of shit, man. If he sent this, and I'm gonna say alleged because I don't want that employee coming after me. But if he allegedly sent this stuff to himself, because I don't know if his fingers were actually clacking on the keyboard and it was sent it to himself. So I'm gonna say allegedly sent to himself. But goodness gracious, this is a lot of stuff. Okay. So that's interesting. So he also sent. Oh, he sent more. There was a second. There's a second page. There's a second page. Revenue goals, flow charts, considering alternative manufacturing processes, cost of effectuating manufacturing changes, future outlook, 24-month outlook. This is a lot of stuff that he allegedly sent to himself. This is a lot. Many of these proprietary documents were stamped confidential. They also, here's something that was not in the last one. Here's something that was not in the last one, guys. There are manufacturing facilities on his phone, transferred those photos to his Gmail account. According to Benchmade, those photos were of highly specialized manufacturing equipment specific to the knife manufacturing, the development of that, which took years in significant. Okay. A capital expense is something that a company invests in themselves so that they can be successful in the future. Some of this stuff might be multi-million-dollar pieces of equipment that's proprietary to Benchmade. They're alleging that he took photos and sent them to his damn. How did they figure? I guess was it a Benchmade phone? How did they figure that out? I don't know. One of the photos is a machine that is uniquely designed for Benchmade with Benchmade expert guidance. I was provided with copies of those emails and the underlying photographs. Now, the photographs are not in this thing, but we will see them one day if this continues. If it gets unsealed, because right now there are some sealed documents, guys. There's 2 sealed documents, and I think those sealed documents contain the photos, and so I couldn't get those. But if those are unsealed, then we'll see those photos. Benchmade employees raised concerns that these documents, if shared with competitors seeking to enter the knife market, potentially could be used to unfairly compete with Benchmade. The Benchmade employees I interviewed explained that collectively these documents would serve as a roadmap. Okay, so he interviewed a bunch of people and explained how this would be bad for Benchmade. Okay, all right. So that's interesting. That is interesting, right? So Benchmade IT personnel also informed me that they conducted a comprehensive search of John Doe's emails and found that as far back as Benchmade's emails were retained, he had never done this before. So they looked all the way back. They said that he didn't start doing this until a few months before he gave the notice that he was about to quit. So, going back for years, he had never done this before. Maybe if he had done it before, maybe he could have an explanation like, hey, I like working off my MacBook. You gave me a PC, FPCs. I don't know. Some people have weird explanations like that. They also said that there would be not a legitimate reason for him to send this type of stuff to his email, but that they gave him access to a VPN. Then he says that I filed a complaint on March 15th. Now, here's the thing that I don't understand, guys. He did all this investigation before he filed the complaint. Why did he not send a cease and desist to either the employee or to MKC? This is the part I don't understand. I don't get this. Like, why? I don't understand why there wasn't a cease and desist filed. You just jumped straight to a complaint. Maybe I'm tripping. Maybe it was, but as I understand it, it was not. None of that stuff happened. Right? I understand that on March 20th, 2024, Benchmade leadership confronted John Doe about confidential documents. He said, I understand that. So was he not in the room? And that he forwarded to his own personal email. He was also provided a draft amendment complaint of adding him as a co-defendant in the lawsuit in a true and correct copy, which is attached as attachment number 2. So exhibit number 2. So I guess he drafted this lawyer but they confronted him. I don't know, because he said, I understand that. When you make that type of statement, that means that leads me to believe you weren't there. I don't know, but maybe you did the draft. I am informed that another statement. So I guess Benchmade is telling him directly. I am informed that during that meeting, Benchmade executives concluded by making John Doe an offer. We talked about those offers. We talked about how he hired a lawyer. The lawyer basically didn't do shit. So we can skip that part because we already talked about that, the couple of weeks of negotiations and all the other type of stuff. So, all right. So here we are right here. While negotiating the settlement with John Doe on March 27th, I received a letter from Mr. Palatori, which is attached to his undersigned declaration. The letter contains a number of false and uninformed statements and threatened a motion pursuant to Rule 11. The letter did not ask for a telephone number, or even a response. Mr. Palatori did not call me. Given the statement of negotiations with John Doe, we continue to focus on trying to resolve those rather than to respond. So this is them explaining to the judge why they didn't respond to MKC's letter. They're saying, well, you didn't ask us to call you and you didn't ask for a response. So that's that. That's how that sounds to me. Am I mistaken? I feel like as a grown man, me personally, this is just me speaking outside of this document. If I take the time to construct a letter, not a text, not a phone call, but I construct a letter and I send it to you, I think that almost says that you want a response. Does it not? So they're saying, well, they didn't ask for a phone call, they didn't ask for a response, so we just focused on our negotiating with the employee. By early April, we had reached an agreement in principle with John Doe in written form. Accordingly, on April 8th, before Montana Knife Company had to file their answer to complaint, I voluntarily dismissed the lawsuit against Montana Knife Company on Benchmade's behalf. But you still hadn't said that I then went and talked to MKC. I did this, I did that. These are the parts that I'm not a big fan of. And if I get a chance to talk to you, Benchmade, or talk to this lawyer, I'm going to ask why you didn't do that. So if you're watching this, that's a question that's coming from me. Ultimately, John Doe agreed to return all of Benchmade's property, allow for a forensic analysis of his equipment, provide an interview to Benchmade's counsel, and abide by a 2-year non-compete. Listen, I'm still on this fact. I still feel like this dude wasted his money getting a lawyer. That's just still my opinion. John Doe did not agree to the 4-year part, and the final settlement agreement does not include that, and they reserve all rights, et cetera, et cetera. After we successfully resolved the immediate case on Saturday, April 20th, Mr. Palatori sent me a draft motion for sanctions. So April 8th to the 20th, did y'all talk to him? Did you reach out to him? Because up until this point, up until April 20th, he had sent you a letter in March, and I think another letter in April, and you hadn't responded. Now he sends you a draft motion, and then you respond. A true and correct copy is also Exhibit 3. So he decided to meet with him on a Sunday. You see how this became urgent, guys? On the 20th of Saturday, he sent me this draft. I decided to meet with him on April 21st, which is a Sunday. Why didn't you agree to meet with him during the letter phase of this? While I was traveling. He also agreed to meet on the 24th. He said that he didn't inform me that he was going to use an AI note-taking software. I need to figure that shit out. He says, nor did he have my consent to do so, though he later disclosed in an unsigned declaration. But it sounds like he didn't break a law. I think if he would have broke a law, you would have said he violated Oregon law, blah, 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 but you didn't. So maybe that recording is going to stay just fine. During our meeting and confer, I explained to Mr. Palatori that given the substantial deficiencies, the draft motion was meritless. I also explained that I did not expect such a basis motion to be looked favorably upon the court, and respectfully suggested that Montana Knife exercise good judgment and not to file it. Here's where Marine X gets drawn into this thing. In a recent press junket, Mr. Palatori stated that in referencing my experience and familiarity with Judge Simon, I was playing on the fact that Mr. Palatori was an out-of-towner. And see, Trump's ex-lawyer, MKC owner, what's next for the Benchmade lawsuit? Oh, really? So what is that? And what do you think he was inferring when he mentioned that he knows the judge? And that would be to get yourself in front of the judge for the very first time in that way may not be ideal. What do you think he was inferring?
He was, playing on the fact that I'm an out-of-towner. And, this is something that I deal with all the time. I mean, I don't have a local practice. I have a national practice. I try cases all over the country. So I don't have, that local courthouse where, all the judges know me, the same way that these other guys do. And so he was making the point of, I know the judge. The judge isn't going to hurt me. You're the out-of-towner. And so the judge is going to side with me because he likes me. That was the impression that I took from it. But from my perspective, okay, if the judge knows you, the judge probably is not going to be that happy finding out that somebody they know is filing a lawsuit without any basis whatsoever.
So that was Tim Palatori and Montana Knife Company's take on it. Sounds like he was just giving his opinion. But they saw my interview. They put it into the complaint as well. It says, this is incorrect. I neither stated nor insinuated that the motion would be looked upon with disfavor because Mr. Palatori is out of town, because I have experience with Judge Simon. I explained that in my experience is not going to be well received because it's filed without misstatements, unsupported, and entirely without merit. They're going to have to duke this out because from what I read and what I saw and what he recorded, I don't know if this is exactly true. And also, I don't know what would be the point of bringing that up on the phone call. Right? Like, what would be the point of that? David says, didn't they just refer him as a New York attorney? Yeah, he just said that like the very beginning, did he not? Right. So I don't know. That's something to think about. I have never spoken to John Doe. Nobody at SWAP has ever directly communicated with John Doe about this matter. So it seems like the only people that have talked to John Doe are the internal lawyers to Benchmade, like the warm bodies that get paid by Benchmade as a salary, right? And Benchmade executives, because this outside lawyer says nobody at this law firm has talked to him. Contrary to Mr. Palatori's representation as the motion, I was not in the room during Benchmade's discussions. Okay, so this is something that is going to have to be that John Doe's going to have to get on the stand or make a declaration about, because Tim Palatori is putting his motion what was told to him. And he also says, contrary to the allegations, I didn't meet with in private at all. The other allegations about me are also untrue. I swear under perjury of law, everything that he just said. Now, I'm not going to read this next part because this next part, and guys, if you want to copy this, join my Discord. Join my Discord, themarinex.com/Discord. I'll put this in the Discord. You can download this document, but I am not going to read this entire non-compete because it's wordy. Like I said, I don't understand parts of it, but this is the non-compete that this guy signed. This is the non-compete that this guy signed. And so I'll throw this in here. Hold on, let me throw this in here real quick. And if you want, there's a Discord. I'm going to, once I get done with this, I will actually put this document in here. Let's end this poll real quick. So for this poll, it looks like we got 97 votes. People are a big fan of coffee. You guys got good freaking heads on your shoulders. Y'all got some good heads on your shoulders, man. Let's pin that message for the Discord, man. All right, so we pin that up there. All right, so this is the non-compete, but I'm gonna just scroll past all this, let you guys read this. If you, matter of fact, let me go back to this main screen so I don't make you guys dizzy. Scroll past this. And they talk about the arbitration process, which I'm still a little confused why you're suing Montana Knife Company where there's an arbitration process, etc., etc. And then they have the actual employee signature right here. Okay, so he signed this in September of 2015. Okay, so he signed that September 2015. Let me jump to where I want to go next. The demand for, okay, here's a part that I think is interesting. Now it seems like that Benchmade is now, guys, I don't know if this is the draft or if this is, they're actually adding the they're actually adding John Doe as a part of the complaint, and they're about to actually take this up a notch. This is the part that confused me, and a lawyer is going to have to go through this. But so this is now complaints against, this is the entire complaint that I guess that they were ready to file. And I'm just going to go over this real quick and talk about what they were asking for to be resolved. And because I'm not sure if this is a draft or if they actually filed this. Let me read this top real quick. No, they filed this. It says filed on the 17th, page 1 of 22. All right. Well, anyway, let's look at this real quick. They're demanding a jury trial. They're now naming John Doe and Montana Knife Company. Wait, what? Am I tripping? Am I misreading this? Bro, am I misreading this? I feel like Benchmade takes shots at people a lot. It says Benchmade Knife Company, an Oregon corporation, John Doe, an individual, and Montana Knife Company, a foreign corporation. Am I tripping? Isn't Benchmade in Montana, or Montana Knife Companies in Montana? Are they not? Am I tripping? Did somebody forget to delete this part? Benchmade, man, y'all trip me out, bro. Either somebody put this draft together using old paperwork, or you know something I don't know. All right, so this action is a misappropriation of trade secrets, breach of contract, and breach of fiduciary duties. So here's something that's different, guys. Benchmade seeks injunctive relief against John Doe and injunctive relief in monetary relief against MKC. They want money from MKC and they want injunctive relief. They don't want any money from John Doe. They talk about the parties. Yeah, they even list Montana Knife Company's address, which is in freaking Frenchtown, Montana. That's a little bit of a swipe on page 1. Then they argue why this is the proper jurisdiction, right? And I'm not going to read that part, but this is them arguing like this is why we should file this in Oregon and not file it anywhere else, blah, 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 blah. Then they give another background of Benchmade and how awesome that they think they are. I'm going to go past that part as well. They talk about their security systems, their visitor badges, all this type of stuff. So they go on. Let me jump forward because I don't want to make you guys dizzy, because one thing is I don't understand if they have now filed this, it seems like they're turning this up a notch. Like they've turned this up a notch, and that they're now, this is what they would have filed against the employee. But this is the thing that I'm confused about. And this is where I have the response that came from Montana Knife Company. Oh, okay. You're saying it. I think they're referring to another state. They refer to them as a foreign. Oh, okay. Okay. You know why I say that is because for me, what I do when I use the word foreign entity, I'm talking about someone that's not incorporated in the United States. All right. I want to jump down to. All right, I'm going to jump down to the conspiracy part. Defendant's conspiracy. So up until this point, I just passed by. They talked about the defendant's work history. They talked about him getting promoted. They said they hired him in 2015, and he basically did well at his work, and he got promoted to his current position. So I just skipped all that part, okay? Because a lot of that stuff we kind of went over, but the new information was he didn't get hired in that position in 2015. He got promoted up to that position. Okay. Here's a new part. This is what Benchmade is alleging. Now, if this is still in draft or this is filed, I don't know, but I have their response and we'll talk about that here in a second. So upon information belief, John Doe decided to leave Benchmade in the fall. Thereafter, John Doe and MKC entered a conspiracy to breach the defendant's fiduciary duties, and that he would submit his resignation and would after take new employment 1 year period of time. They think that MKC and the employee conspired to come up with this 1 year period of time. I don't know what evidence they got of that, but that's what they think. Defendants conspired to effectuate this plan, notwithstanding John Doe's non-compete agreement with Benchmade, which limited him to engage with competitive business for 2 years. They also believe that John Doe's theft of trade secrets. Then they dive deep into these trade secrets that he took. They says in October he started forwarding stuff. Now they specifically tell us where he sent the shit. Gmail accounts. That he sent Excel spreadsheets. He sent the job. He sent other employees' names, and they think that he sent other employees' names so that these people can be poached as well. I don't know why would he send other employees sensitive employee information such as their names, their job titles, their hire dates, their compensation, how much they were getting paid, date and the last reason for their pay increases, current hourly rates. This information particularly in this specific form is Benchmade trade secret. At a minimum, it's confidential, proprietary, including but not limited to the automation and engineering roles. There was no legitimate reason for John Doe to forward this stuff to his personal email. Then they talk about the other stuff that he forwarded to himself. We've talked about that before. Let's see. Information he forwarded himself. Termination of the employee at Benchmade. And they talked about on February 26th, he gave notice. So I think that this is the actual draft that they were going to file. But I don't know if they're just giving this to the judge to show what they were going to file or if they've actually filed this. But we're going to talk about what they're requesting for a prayer for relief if they've actually filed this against Montana Knife Company. I'm going to give you Montana Knife Company's response that they gave me last night. And then I'm going to give you my summary, what I think so far. Prayer for relief. This is what the prayer for relief is for this specific document. Wherefore, Benchmade prayers for relief from the report. Preliminary and preventative injunctive relief, compelling to return all information. Yeah, this must be the draft because they said that they've already gotten all this stuff back. Injunctive relief, so forth and so on. Compelling them allow a third party to access those devices. Preliminary permanent injunctive relief to comply with the 2-year agreement. And as against Montana Knife Company, they want an economical and non-economical damages. They want money to be proven at trial. As against MKC, they want punitive damages. They want attorney's fees. Okay, I guess they didn't file this because it says it's unsigned. Now, the thing about this, the thing that I think about this, guys, is overall, I'm a little confused as to why, up until this point, why Benchmade did not send a cease and desist before they filed this initial action. Something in my bones just tells me that this could have been resolved, before filing an actual lawsuit. Like, am I tripping? Am I tripping about that or what? Like, I feel like this could have been resolved before filing an actual lawsuit. All right, so the response from, let's see, without disclosing their information. All right. All right, so this is a response from Tim Palatori. This is a response from Tim Palatori, a lawyer from Montana Knife Company. Benchmade's response fails to contradict the main thrust of our motion. They have filed a lawsuit against Montana Knife Company without a shred of evidence against Montana Knife Company. Their thin denials actually reveal their frivolity. Whew, that's a word. And underscores the impropriety in their conduct. We will be filing our reply next Friday and expect to prevail. The response from Montana Knife Company's owner, Josh Smith, he says basically, they don't have anything on us. You see how the lawyers, like, it's nice and lawyerly, right? And then you get a good old boy with that Montana man speak. He says, yeah, they basically don't have anything on us. That's why that's why I knew the lawsuit was ridiculous from the start. He says that if they would have just talked to their own employee at the end, they could have avoided all this. It's unfortunate that they don't trust their employees, that they don't treat their employees with respect, especially those that dedicated so much to their growth. So Montana Knife Company the owner believes that they should have just talked to the employee. They could have resolved this. Tim Palatori believes that they filed a lawsuit against Montana Knife Company and they didn't allege Montana Knife Company to actually do anything. So that's their official response that I've gotten from them thus far. Okay. What do you guys think about this before I give you my summary of what I think? What do you think about this before I give you a summary of what I think? So Benchmade has responded. Benchmade has responded with a bunch of emails that they're saying that this employee sent to himself. They're saying that he shouldn't have sent this stuff to himself. But I'm going to keep it real with y'all. That response, because what Benchmade responded to, they're saying that you should not grant Montana Knife Company's request for lawyers' fees and for court costs because the employee emailed the stuff to him. I'm still confused why the argument didn't make sense to me. It still does not make sense to me why one, Benchmade did not send a cease and desist to MKC before they filed. Two, before they dismissed it, they didn't talk to MKC to tell them why they're dismissing it. Three, they didn't initially file suit against the employee. And four, why did you ignore Tim Palatori's emails initially or letters initially? Those are all still on the fence about me. Benchmade, if we get a chance to talk, I'm going to ask you these questions because they're not adding up to me. This is important, in my opinion, that people that do EDC that are into knives, because we want to know the integrity of folks that are doing business that we're buying from is something that we can just be fully disclosed about. And if we want to continue to give our ducats to you, we just need to have an understanding of where you lie, right? Because if you don't have the best practices or something like that, maybe I don't want to continue to give my money to you. But to be fair, Benchmade has had a lot of fights to keep their patents, their trade secrets. They've prevailed in 2017 against a company that was trying to take some of their copyright, 2023. So they've had to fight hard. And it seems like they just come out fighting when they think their trade secrets are at risk. This may be an instance that your trade secrets weren't at risk from MKC, but I don't know yet. I don't know. It does feel a little icky to me, though. It feels a little icky to me. So you have Benchmade's response to the motion. They've disclosed that this employee has released all these emails. Woo, goodness gracious. I don't know if this employee's, this guy, I don't know if his career in the knife community is done. If this stuff is true, who could trust him working for them in the knife community ever again? And the reason I didn't disclose his name in this live stream, although I easily found it, is because he's still a man. He still has a family. He still has kids. And a man should be allowed to eat. It's like Mike Vick fought them dogs. And I thought that was disgusting because I love dogs. I love dogs enough. He should be allowed to eat, right, in the future. And so this should not be a death sentence to his career, but it may not be something he can do in the future in a knife company if this is true. But if it is true, I look forward to seeing Montana Knife Company's response. Benchmade, I have opened the door for you to come on for an interview if you want to talk about this. And as it stands right now, it still makes me feel real icky that you not inform them prior to that you filed any of this stuff. Like, that's the part that makes me feel the most icky. Let's see. Benchmade is tripping. I think they were referring to another state. So they didn't drop the lawsuit, says Chris. I don't know. It seems like that they didn't file that draft motion. But Phytonic says doesn't make sense. The information he supposedly stole is useless to him. So it may be useless to him directly, but some of that information, like, excuse me, if you know how much other employees should be paid and stuff like that, the reason that that could be important is so that if you disclose that to a future company, you can say, hey, you're overpaying these guys, or this is how much they make. If you want to attract other people that are similar, this is the type of salary you're going to have to pay. Why do you know that? Because I have all the information. So that's some trade secrets that you may not want to be disclosed when it comes to your business, et cetera, et cetera. But more on this to come, guys. I am 1 minute over for the conclusion of my lunch. So I'm going to wrap it up here, guys. Make sure you hit that like button, hit the subscribe button if this is your first time stopping by. Comment down below, share this video with other folks, and we will speak soon.